Today's topic is how do criminal defense attorneys get cases dismissed? If you've recently been accused of a crime, or if you're interested in this topic, stick around. I think you're gonna like this video. My name is Dod. I've been a criminal defense attorney here in San Diego County since 2004. My firm is Dod Law. If you like this video, hit that like button. You can also subscribe to our channel. We're trying to educate the public. We're trying to get the public the help they need. Today's topic, we're going to talk about how defense attorneys get the case dismissed. Now, I've been doing this for a very long time, and every single call I get, my clients or potential clients and family members want to know, can we get the case dismissed? It's very common for the mother or the father to tell us, well, my son is a great kid, my daughter is a great kid, he would have never done that, we need the case dismissed. We understand that. We get these calls every single day about getting a case dismissed. Now, I'm sorry to inform you, it's difficult to get a criminal case dismissed, especially if charges have already been filed. If charges have been filed against you, you already have your back up against the wall. But let's talk about it. Now, the first way and the best way we can try to get a case dismissed is in the pre-filing phase, meaning you were recently arrested, for example, domestic violence, a theft charge, an assault with a deadly weapon, a bar fight, a fight at school. You've been recently arrested, and now the prosecutor has to decide whether or not they're going to file charges. That's where you get the attorney negotiates with the prosecutor, we present mitigation, everything about you, in hopes that we can get the prosecutor not to file charges. In a domestic violence case or in an assault case, do we have a valid self-defense claim? Because remember, in order for a prosecutor to file charges against you, they have to ethically believe that they can prove their case beyond a reasonable doubt. So it's our job as the attorney to get in there early before charges are filed and convince the prosecutor that they cannot prove this case beyond a reasonable doubt. And here are the reasons why. Now, if they do file charges, it's a whole different story. It is a lot harder to get your case dismissed if charges have been filed, but it's still possible. What your attorney will do, and remember, this is not legal advice, you and your attorney can go over your game plan, but typically there are various ways to get cases dismissed once charges are filed. Number one, again, we can try to convince the prosecutor that they cannot prove the case beyond a reasonable doubt. There's a valid self-defense claim. Number two, we can file motions. For example, a Fourth Amendment motion. The Fourth Amendment protects you against unreasonable searches and seizures. So for example, if you're driving a vehicle and an officer pulls you over and there's no reason for them to pull you over and they find drugs in your car, they find other contraband, then we can run a motion and say that the search was unlawful, your Fourth Amendment rights were violated, whatever they found was fruits of the poisonous tree, case gets dismissed. That's one way. Another way is if we file a pretrial miranda motion. Miranda meaning your Miranda rights were violated. And remember, when an officer pulls you over and you're in custody, custody means you're not free to leave, and they're asking you questions in an attempt to elicit an incriminating response, and you make an incriminating response without Miranda rights being read to you, those statements that you've given are going to be excluded. However, if there's other corroborating evidence of your guilt, then your case won't get dismissed. But if all they have to prove your guilt is your statements, then your statements are excluded. The case will most likely get dismissed. The other ways we can get cases dismissed is if we can show the prosecutor that this is a mistaken identity case. There's surveillance video, there's other evidence showing that this isn't you. There's eyewitnesses that can say that this isn't you. That's another way to get the case dismissed. In a felony case, we can get a case dismissed at a preliminary hearing. We go to a preliminary hearing and we cross-examine witnesses, and then we argue to the judge that there's insufficient evidence at this point for the judge to bind you over to go to that next step, and then the judge can dismiss the case. So that's another opportunity to get your case dismissed. Then there are other options. For example, we can go to trial and we can win at trial, get a not guilty verdict, then your case is done. If the case is hung at jury trial, meaning, for example, 11 people think you're guilty, 1 think you're not guilty, or vice versa, 1 not guilty, 11 guilty, or a split jury, 6 versus 6, then the judge can, on their own motion, make a motion to dismiss. Or you can try the case again, get another hung jury, and then a judge at that point can dismiss the case. Then there's other options that we can get the case dismissed, but they become less and less likely. For example, your speedy trial rights were violated. You weren't brought to court within the allotted statute, and it all depends on, state by state, what the statute of limitations is on certain cases in your state. Or the other option, which doesn't happen very often, is a due process violation. For example, let's say somebody is charged with murder, and 20 years from now, or 20 years ago, the case happened. It's a cold case, and now they're before you at trial. Well, all the evidence that was gathered at that scene 20 years ago, all the witnesses have died, all the evidence and everything has been thrown away or destroyed. You have a valid due process argument. So, to summarize, how do criminal defense attorneys get cases dismissed? The best way is before charges are filed. Rejected, dismissed before charges are filed. Once charges are filed, we have our back up against the wall. We still can get the case dismissed. We can file motions, pretrial motions, a Fourth Amendment violation of your search and seizure. We can file Miranda motions. You're in custody, you're being interrogated, your statements are excluded. It's a mistaken identity case. We can go to preliminary hearing. We can beat the case at preliminary hearing. We can go to trial, beat the case at trial, get a hung jury. Due process violations, speedy trial violations. There are other ways to get the cases dismissed, but these are just a few examples. I hope you like this video. If you like this video, hit that like button, subscribe to our channel. If you have any questions, please give me a call. My name is Dod. I've been a criminal defense attorney since 2004, and if you want to talk about your case, go ahead and give us a call. Thank you very much for listening. Have a great day.